The morning report with Rachel Baird and Ed Peruta. Ed Peruta is not here today. Usually Kryschenko joins us on Thursdays, but it's getting to be nice weather. I think it's either the first or second day of the summer, so we have given Chris the day off to relax and perhaps take some time in the sun. So it'll be me today, and off camera will be Dan Lynch. We will be discussing a situation that has come to my attention that we're going to be getting more details about it as time goes on. So I want to speak in general terms about this situation. Now let me start to run this by Dan Lynch, and you'll only hear his voice off camera. Here in Connecticut,
until somebody sponsors my wardrobe, I'm going to be off camera.
Here in Connecticut, we have a Division of Criminal Justice. And the Division of Criminal Justice is a statewide agency. And there are within that agency state's attorneys who are responsible for the various judicial districts in Connecticut. And those state's attorneys supervise assistant state's attorneys, deputy assistant state's attorneys, and supervisory assistant state's attorneys. But they are all state employees. Now this differs from a lot of states where there are DAs that are employed by various counties, or I'm not sure it ever goes to a municipal level prosecution, but I'm just saying in Connecticut, prosecutors are state employees. Now, I had an opportunity to read the other day an ethics opinion, two ethics opinions. Judges or anyone, I guess, who's an attorney can ask for an informal ethics opinion.
A judicial ethics opinion, or?
I believe they were, yes. They were judges asking the question. Well, I'm assuming they were judges asking the question because it pertained to judges' activities, but maybe somebody else could ask about a judge's activity, right?
Okay, so there's the judicial ethics, which is one group, but then there's also the Citizens Ethics Advisory Board, which is part of the Office of State Ethics.
Okay. Now, does that have to do with elections or just employment in general?
You know, I think it's, I don't know. I can't say. But,
you know, you look really good with that flag behind you. I wish everybody could see it. But,
but the Judicial Ethics Committee is separate from the Office of State Ethics.
Okay, so in one decision, which doesn't exactly pertain to this issue, but I started out with it, there was a judge who was going to be given an award by Mothers Against Drunk Driving at a banquet or a ceremony. And the question was asked, is there an appearance of impropriety? Is this ethical to do this? And the ethics opinion, in fact, came out and said, yes, this does violate ethics. You can't accept this award because it takes away from the objectivity, you know, of your position. And that's online. It can be looked up. So then there was another ethics opinion that I looked at, and it involved a new type of organization that has been in the works since about 2013, I guess. There are these organizations popping up over the country, and there's one in San Diego called Family Justice Centers. And what they seek to do is combine the efforts of police, prosecutors, family court, not family court, but family relations advisors, all into a non-governmental center where victims can go for all their needs, let's say. And so in Connecticut, down in Fairfield County, there's one of these family justice centers who sort of took their template from the San Diego Family Justice Center, and they're starting the Center for Family Justice.
Is it new? Is it going to be relatively new? I'm not familiar with it.
I believe it's already in the works. I know in 2013 they were attempting to put it all together with the police chiefs and a couple prosecutors down there. And there was an ethical opinion where a judge had asked, can I get involved in this, basically? And the opinion was, no, you can't, because it appears to be an advocacy group that is definitely strongly for victims. Nothing wrong with that. But when you're a judge, getting involved in something like that makes it seem like when you're sitting on the bench and defendants are charged with family domestic violence crimes, you may be less than objective.
Well, and you also may have, litigants coming before you on both sides for dissolution of marriage.
Yes, good point.
And so, and the reason this immediately comes to mind is a few years back, there were 3 judges who were on the wrong side of an ethics opinion, so to speak. There were 3 judges in Connecticut who were members of an organization called, a matter of fact, not members, they were board members of an organization called the AFCC. I think it stands for the Association of Family and Conciliation Courts. Nationwide organization. I mean, there were, and this has been a hot button here in the state of Connecticut, because you had 3 sitting judges who were on the board of directors, and then that organization was making appointments, or that organization had members. Among the members were guardian ad litems. You had some of these same judges making appointments of guardians ad litems who were members of the organization that they were, on the board of directors. Very, very messy situation. And the ethics opinion came out and said, yeah, that's improper, and all 3 judges had to step down.
Good, because that's very relevant to this. What's going on in Fairfield County is there's a prosecutor in Bridgeport. I believe she's in Bridgeport, yes. And she does the domestic violence docket, and her name is Judy Stevens. And she sits on the board, and I think she's its chairwoman
for the Family Justice Center.
For the Family Justice Center. And the Family Justice Center advocates for victims, provides services, a place to go, etc. Works with the police.
Which is good. Which is
good.
Yeah.
But the problem is, when you're a prosecutor and you're involved in an advocacy organization like that, some of the very people who are using your services at that advocacy organization are also victims in the court system of people that you're prosecuting, and you're going to be using them as witnesses. And so...
Some of them are also defendants.
And some of them are also defendants,
right.
Correct. And does it take away from the objectivity of a prosecutor the pursuit of justice, not of convictions, but of justice, the truth?
Does it take away in an actual sense? And then the second question I would ask is, does it give the appearance of taking away objectivity? And so I think those 2 questions are relevant. Is there an actual bias, and is there a perception of bias?
Well, let me give you some examples. What about if at the advocacy group there are sessions that are group sessions, there's no confidentiality, and the victim makes some statement about, I'm not sure it really happened the way I put it in the statement that I gave to the police. I seem to be remembering some more things. Or I have information, some tape recordings that I shouldn't have taken because there wasn't party consent, but I have this. What obligation does the prosecutor, who's also on the board and involved in the advocacy organization, have to turn this information over to the defense attorney, any exculpatory information over to the defense attorney? And should victims who go to this advocacy group be told that, there are law enforcement people involved in this group, and they have a duty, if they find out anything exculpatory to the defendant's case, to turn it over to the defense attorney? Should those victims be told that? What a messy, messy situation. And you know what? If we sat here and thought about it, I bet we could come up with a lot more scenarios where it just cannot be right for either a judge or a prosecutor to be involved in an advocacy group where people are coming to that group for help who are also going to be in court involved in cases that the judge or prosecutor is involved in, where each has a duty to justice and the truth. It just appears to be a conflict of interest to me.
You know, it's an interesting topic. I was, sadly, I guess still am. I mean, I've been involved in the Bridgeport area, the Judicial District of Fairfield at Bridgeport, I guess is what they call it. Thankfully, not the GA court. But in the Bridgeport area for 9 years. It sounds like this center is certainly one that makes a lot of sense to have the function. I think it's needed. But I start thinking, as you're talking about this, now I had not heard about this, but I start thinking, I hate to say the word nightmare. I mean, that's the first word that comes to mind. I mean, obviously there's other things that are more serious, but this becomes a real sticky issue. I start thinking about the little interconnections between various judges and attorneys, and I'm not familiar with the prosecutors down there. I guess in only one interaction. I think it leads down an awful slippery slope.
And like in a lot of cases where you're looking at them and trying to figure them out, in this case, there's the issue of money. I mean, we have access to a lot of emails actually, where a large portion of the discussion is about seeking grant money for the Center for Family Justice. And how appropriate is it for prosecutors to be involved in seeking grant money for organizations involved in activity related to their work where the money is for those organizations through grant money? I have a feeling, like in a lot of things, if the money trail is looked at, there's going to be a lot more information made available.
Well, as they always say, right? Follow the money, follow the money, follow the money.
Yeah, so I saw one email that disturbed me. I saw a lot of them that disturbed me, but you got to put it in context, and this is still the beginning of looking into this area, where a prosecutor wrote a pretty lengthy email to police chiefs down in the Fairfield County area saying, I was talking to a judge, and the judge says that you need to do your family violence cases investigation better. You need to take statements, you need to take pictures, you need to do this, you need to do that. How appropriate is it for a judge to be counseling the prosecutor about what to tell law enforcement on how to do their cases better? I don't know. It may be okay. I mean, I know judges give seminars about, where defense attorneys can attend and get insight into what a judge thinks about and all this. So maybe it's entirely appropriate. I don't know.
Now, I just want to make sure I understand. So, as part of the Family Justice Center, I'm making I think, reasonable assumption, but we all know the adage about it if you make an assumption. So I'm making a reasonable, kind of educated guess here that disclosures that take place within the context of an advocacy, someone comes to the Family Justice Center because of maybe violence or discrimination or whatever their issues are that they come. I'm in my mind, I'm thinking that activity is confidential.
I guess it depends who they're talking to, and yeah, maybe that's the next area we should go in, because there's a set of statutes in Connecticut that lays out where the confidentiality lies and where it doesn't. And a lot of people think in certain situations there's confidentiality when in fact there's not.
Yeah. And the reason I bring that up is, as soon as you started talking about this, my mind started going down the avenue of rule violations on the part of either jurists or attorneys who are prosecutors. I mean, there is a special rule for attorneys as prosecutors, I think, and I'm trying to find it. I think it's Rule 3.7.
You know, I looked it up and I didn't see anything particularly specific to this situation. But I looked it up quickly yesterday. I mean, I was
But
just...
the attorney
yeah.
acting in his role as prosecutor?
Yeah, it was...
But but in that example that you used, though, I mean, if somebody makes a disclosure or seeks assistance on something, and now the attorney who's acting as a prosecutor, through their advocacy role, suddenly becomes aware of some information of any, you know, of an activity or a lack of activity or something that could help the case. So that's kind of what I'll say. It's outside the record of the criminal prosecution, but it's something that's going on in the Family Justice Center. They have knowledge of it. They can't turn a blind eye. They can't continue with a prosecution if they know from any context that it's an inappropriate prosecution.
Yeah, let's take that theory to the extreme. Let's say that a prosecutor also happens to have a degree, a medical degree, and is a psychiatrist. And on their off time, they take patients as a psychiatrist. And one of the patients that comes to them is a victim of domestic violence. And then lo and behold, the next day the prosecutor shows up in court, and that victim of domestic violence, who the day before they saw as a psychiatrist, is now standing in the courtroom as a victim of a person whom the prosecutor is prosecuting. I mean, that is obviously not right. Obviously not right. And I think this situation, having a prosecutor, one or more, involved with a Center for Family Justice that advocates for victims, lends itself to that kind of conflict. Yeah. There's no doubt about it.
And at minimum, an appearance of a conflict. At minimum. I think that many reasonable minds would look to this and say, yeah, that doesn't seem quite right. How could you maintain your objectivity? You know, especially if you look at a situation where at some point in the process, the judge sitting on the bench might match up with the prosecutor, who they both are part of this organization. Now, maybe in that case, it's
now
easier.
Judges have been told in the ethics opinion not to be involved.
Okay.
But
right. So that opinion just came out. So it's possible somewhere in the state you may have a judge or two who need to step down. I'm not suggesting that the judges were intentionally doing anything sleight of hand, but that, you know, the same way as the other organization, you know, somebody looked at it, and a judge who might think, geez, I'm doing exactly what they'd want me to do as a jurist, right? Maybe they were appointed a year ago, and one of the things, as part of the judicial selection process and appointment process, one of the things they encourage is involvement in the community and be out there and help to face you. So maybe they think, well, this is a perfectly good thing for me to be doing, representing the bench in an advocacy type role. And now they, you know, in some degrees maybe get their wrist slapped a little bit.
And I just want to clarify one thing that I find a lot of people don't understand, is that prosecutors do not represent the victim. They represent the people of the state of Connecticut. And the reason they don't represent the victim is because they are seeking justice in the interest of the people at large. And a lot of times the victim's interest may not comport with that. The prosecutor, if the prosecutor believes that the victim is being untruthful, is not being forthcoming, has to point that out. The prosecutor is not there to defend the victim, to seek justice for the victim. The prosecutor's there for the state, the people of Connecticut. Okay, let's get a call in from Ed this morning. Good morning, Mr. Peruta.
How are you?
Good. You see Dan's off camera here today.
I see you looking to the left, my left, your right. Is he sitting in a chair off camera?
He is. He's in front of the flag over there.
And
it's probably because he's wearing a tutu.
I don't know why he didn't sit right in front of me.
And I'm seeking sponsors. Well, there's a camera right in front of you.
Oh, okay. Well,
Oh, Jesus.
You know, sometimes at the end of the news programs, you know, you see that, you know, Men's Warehouse, this wardrobe provided by Men's Warehouse or something. So.
Oh, Jesus.
Let me assure everyone, though, he is clothed. Okay.
So where's Chris Janko?
I guess the weather was too nice for Mr. Janko to show up today. Maybe he forgot it was Thursday.
Oh, Jesus. Well, all I can do is tell you this. Keep talking about the prosecutor does not represent the victim. I'm going to hang up. I've got some errands to run this morning, and I'll see you later this morning.
Okay, great. Bye. Well, what about when there's a dual arrest, which there often are in domestic violence crimes, where each person is both a victim and a defendant? Do they, in other words, does that victim go to the advocacy center where they're also a defendant in their own case? And then how does that affect things?
Yeah, I'm still, I mean, I don't have enough experience to.
We're still getting our feet wet.
To
Me
fully
too.
digest some of this stuff, and so the whole issue of a prosecutor doesn't represent the victim.
No.
So what am I to understand? Then they are representing, when you say the public at large, meaning possible future victims of the same perpetrator of the similar conduct?
Right.
Is that essentially the concept?
Right, exactly. The interests of society. I mean, victims sometimes want certain things to happen in court. They want somebody to be prosecuted for a certain crime and to go to jail. And the prosecutor, for whatever reason, doesn't advocate for that. So representing somebody means advocating for their interest and for what they tell you to do. You know, as the attorney, you have to represent your client.
Right.
And the prosecutor does not do that for a victim. The victim does. And one example is the reason why police officers are told to get statements in domestic violence cases, because a lot of times the victims don't want to go forward. They say, you know what, nothing really happened. I don't want nothing to happen to this guy. Just drop the case. Well, if they have a written statement under oath about what happened, then it's hard for the victim to come back and say nothing happened, because then what the police do to the victim, they say, well, we're going to prosecute you for making a false statement. Well, you know, and prosecutors threaten victims with that too, who have made statements under oath. Well, you made a statement under oath. You're not going to go in there and testify? Well, we're going to prosecute you for making a false statement. So prosecutors only represent the victim so long as the victim serves their interest. Prosecutors want to get a conviction. And if the victim is going to come in there and help them get a conviction, then yeah, we're all on board with the victim. But if the victim is saying, I don't want to go forward, I don't want to do this, no, then we're not on board with the victim anymore. And if the victim has made a false statement, it has made a statement under oath, then the prosecutor can say to the victim, well, we're going to prosecute you for making a false statement now if you don't get up there and testify what you said. So if you ever think the prosecutor represents a victim, just think about that, where the prosecutor can turn on the victim in a dime and say, you made a statement under oath. I don't care if you don't want to testify. I don't care if you don't want this case to go forward. I want the case to go forward because I want that guy in jail, so you're going to get up there and testify. That's not representing somebody. Now, the prosecutor and the victim's interest are often one and the same. I will agree with that. But if the victim's interests diverge from the prosecution goes on to do what it wants, not what the victim wants.
Now, do you have any insight from your days, I guess, as you were a prosecutor at one point?
Right.
Are prosecutors measured when it comes, because after all, they're employees working for somebody, so in this case, the state of Connecticut, when it comes time for their performance appraisal to see, hey, are you a good prosecutor or not? Did you do your job, and are you going to advance? Is it based on the number of cases that move through the system, or is a kind of statistical percentage of convictions to the total cases
It's
pending?
definitely not a percentage of convictions, because number one, there are hardly any trials, so that would really be a hard measurement.
So it's more qualitative, or is it?
It's more of it's more, you look at somebody and you look at their demeanor, you look at how they deal with people, you look at their judgment, and a lot of times judgment is dropping the bad cases, dropping the cases that probably should have never been heard in the first place. And I got to tell you, prosecutors do nollie a lot of cases. I mean, a lot of the stuff gets thrown. That's why you wonder how some stuff gets in when a lot of stuff just gets thrown out.
Now let me, if I may, let me just pause for a second. I want to make sure I understand. I've heard the word for years. A case being nollied versus a case being dropped or dismissed. Are they all saying, is that all saying the same thing? Is there a distinction?
Well, no, a nollie is, what it means is the prosecution's declining to prosecute. I decline to prosecute your case. You may be guilty as hell. There's nothing wrong with the arrest, but you have no record. You told me you felt bad about it. You have a job. You have a family. I'm going to exercise my discretion and decline to prosecute. And after 13 months, it becomes a dismissal. Now, in Connecticut, when a prosecutor nollies a case, the defendant has a right to then ask the judge for dismissal immediately. And then the prosecutor can withdraw that nollie and say, wait a second, you know, I declined to prosecute. I didn't necessarily mean that your case wasn't good or that there wasn't probable cause or all this kind of stuff. So if you're going to go for that dismissal right now, then I'm going to withdraw my nollie. Or the prosecutor may just not object to the dismissal. So that's kind of how it works. Now,
Okay.
if there are grounds for dismissal, whatever, lack of probable cause, whatever, I mean, they're in the practice book, then a defense attorney could move for dismissal and a judge could grant that dismissal. And that's kind of different. That's different than a prosecutor simply exercising discretion not to prosecute. Kind of like a cop. He sees you do something wrong. You're speeding. He stops you. And he's got you cold, but he just decides for whatever reason not to give you a ticket. That happens. Exercise of discretion. Prosecutors can do it too.
Yep.
Yep, so that's what that is.
Okay.
So I forgot what we were discussing before that, though. Oh, yeah, the dynamic between the prosecutor and the victim. As long as they're going down the same pathway, it appears that they're on the same page. But if those pathways diverge, then there's definitely not representation by the prosecution of a victim. And that shows there never was representation of a prosecutor by a victim, So I'm glad I clarified that because a lot of people get that wrong. And victims often hire their own attorneys to go to court. If they feel like the case isn't being treated like they want it to be treated, then an attorney will actually file a appearance for the victim. And I know there's a controversy in Connecticut right now whether the victim's attorney can participate in pretrials in chambers with the judge and the prosecutor. We're going to be looking more into this issue, Dan.
I finally did have a chance to find. So earlier I was referring to the rules, and my memory, I thought it was Rule 3.7, so I was wrong. But I was close. It's Rule 3.8, special responsibilities of a prosecutor.
Okay.
And these are the rules of professional conduct for attorneys in the state of Connecticut. So anybody who wants to kind of dig into that could look at Rule 3.8.
Okay, good. Well, we're going to wind it up today. Thank you, Dan, for joining me. And I know that you will be away this Saturday, and we wish you a good summer trip. We'll try to do our best without you. Everybody have a great weekend, but please tune in this Saturday, Summary Judgment from 4 to 6 p.m., and we'll be back Monday at 7, hopefully with Ed. Hopefully later that day we'll have some news from the Supreme Court as well. Have a great day.